We're happy to have with us today two partners from Atkinson, Anderson, Lawyer, Rude, and Romo, a full-service law firm with over 180 attorneys and 9 offices throughout California. Atkinson Anderson attorneys serve as trusted advisors to more than 7,000 public and private sector clients, with emphasis in the areas of employment, labor, construction, education, real estate, general business and business litigation, corporate taxation, bankruptcy, and immigration. AALRR is a recognized powerhouse in labor and employment law, education law, cities and counties representation, and litigation, with many attorneys having received distinction as super lawyers, best lawyers in America, and other accolades. In addition, Atkinson Anderson is proud to announce its inclusion on the prestigious 2018 U.S. News and World Report and Best Law Firms list, recognized for the firm's professional excellence and persistently impressive ratings from clients and peers. Thomas Lenz handles all aspects of labor and employment law issues and heads the firm's traditional labor and National Labor Relations Board practices. He works with employers in all major industries across California and the West. Mr. Lenz currently serves as chair of the Labor and Employment Section for the State Bar of California. He also serves as a lecturer in law, teaching at the USC Gould School of Law. Cindy S. Arellano is head of AALRR's business and tax team. Her practice focuses on employee benefits and executive compensation, qualified and non-qualified deferred compensation and retirement plans, health and welfare benefit plans, ERISA, tax audits, and other tax controversy matters. She also works with nonprofits, including educational foundations, charitable organizations, and trade associations, and represents clients in general corporate transactional matters, business formations, compensation structuring, and mergers and acquisitions.
Hello, I'm Tom Lenz. I'm a partner with the Atkinson, Anderson, Lawyer, Rude, and Romo law firm based in Pasadena, California. And I'm joined with my partner, Cindy Arellano, in the firm's Cerritos, California office. And we are talking to you today about independent contractor compliance. Thank you for joining us. Independent contractor compliance is a hot issue, and many times you see it spoken about as misclassification. We're going to talk about what misclassification is, the various ways in which the issue arises, the risks and liabilities that can flow from it, and things that you ought to do if you are an employer or counsel advising an employer or other business on these related issues. What is misclassification? It is when a business classifies workers as consultants or independent contractors, really anything other than employees, when in fact the law, whether it's federal or state, considers those individuals to be employees. We often see misclassification issues arise in workplaces where businesses are accused of wage theft, or perhaps not paying their taxes, not paying employees correctly, a variety of different issues which we will talk about. But misclassification is a rampant issue throughout California and other states. So what's new with classification issues? In summary, there is a spike in investigations and enforcement lawsuits by the government. There are changes in the rules going forward. The United States Department of Labor issued interpretive guidelines on misclassification and independent contractor status in 2015 and 2016. The Department of Labor withdrew that interpretive guidance in 2017. The United States Department of Labor has also entered into a memorandum of understanding and joint enforcement agreements with the Internal Revenue Service, IRS, and half of the states in the United States to coordinate efforts to crack down on issues of misclassification. So this is important because the government agencies we often think of as being in sync, but many times they are not. In recent years, under the Obama administration, with DOL and IRS entering into joint enforcement agreements, they really established a plan, a coordinated effort to share resources and to combat this issue. Now, separate and apart from federal government regulation, states, including California, have enacted laws, increased penalties, and taken steps to really make it more difficult and more costly to violate the law through misclassification. The slide you see makes reference to California Labor Code sections 226.8 and 2753 as examples of laws that have come about in this trend toward fighting misclassification. Separate from this, the National Labor Relations Board has expanded what it is to be an employer through its standard for joint employer status, and that is the subject of litigation as we speak. It is the subject of legislative efforts on Capitol Hill. Nonetheless, the National Labor Relations Board is expanding the notion of employment because at all of these different levels we're talking about, there is a prevailing view that people who work are employees and they are subject to the control of a business as their employer to make them employees rather than independent contractors. So federal and state agencies are aggressively investigating misclassification of employees as independent contractors, and the companies that use the largest numbers of contractors are the most vulnerable because there are more people at stake, and accordingly the potential liability and penalties will multiply. So is this something that happens in just one or two industries? No, it happens in a lot of different industries. It happens in trucking, it happens in warehousing work, it happens in the golf and private club industry with golf pros and caddies. It happens really in any sort of workplace you can think of where you might customarily hear someone referred to as a 1099 or an independent contractor. And it's often a workplace where things are informally done and employees or workers, let's say, are paid in cash, or they do not receive the same formality that others who are treated as employees receive. It comes up in a lot of different ways, and as we will discuss, the details matter. But what's important to know is that even in 2017, with some of the rules at Department of Labor changing from the Obama administration to the Trump administration, investigations at DOL resulted in over $270 million in back wages recovered for nearly 250,000 workers. And over 86 million of that was in low wage industries for nearly 100,000 workers. So you don't have to be earning a large six-figure salary. If you are in a low-wage industry and you are misclassified, you are still potentially in a position to raise a claim. So what's new with classification issues, specifically in California? We have the Dynamex ruling, which came out on April 30th, 2018, which is a really significant ruling from the California Supreme Court. It changed the test applicable to independent contractor status and misclassification. And in doing so, it really tipped the scale further than the law had been to find an employee and to make it harder to be a legitimate independent contractor. So the test that the Dynamex court came out with is what's known as the ABC test. And we'll talk about this a little further as we go through the program. And there are three elements. And unless you satisfy all three of those elements, the individual at issue is going to be an employee. So those of you who consider workers to be independent contractors, those of you who advise individuals on independent contractor status, the individual at issue has to satisfy all three of these factors. Factor A of the ABC test, the worker is free from control and direction of the hiring entity. So query, does that business organization control or direct the work that's done by that individual? Factor B, the worker performs work that is outside the usual course of the hiring entity's business. So if you are a company that drives trucks and does warehouse work and you hire people as an independent contractor to drive trucks and do warehouse work, that's not going to satisfy factor B. If you are a trucking company and you hire a plumber to fix a clog in your sink and that plumber does it and goes home, that is more likely an independent contractor. Factor C, the worker is customarily engaged in an independently established business of the same nature as the work being performed. Does this individual have his or her own business? Do they have a license? Do they have business cards, a business name? Are they able to refuse work, accept work in their discretion? Are they able to work outside of that environment to serve other customers? These are really tough questions. They are detail-oriented. It's a very difficult test to meet, especially Part B. With that, I'm going to turn it over to Cindy.
Hello, this is Cindy Arellano. I'm also a partner at Atkinson, Andelson, Loya, Root, and Romo. So why are misclassification issues such a problem? Well, they're a problem because in many cases, both the business and the worker prefer that the worker be treated as an independent contractor rather than an employee. And this is because there are a number of benefits, certainly from the business's perspective, in using an independent contractor. Some of these benefits, and the ones that people primarily think of, are the employment and withholding taxes. If you are using a worker and treating them as an employee, you're going to be subject to complying with all the withholding tax rules and regulations and paying the employer's share of the employment taxes to the IRS and the state taxing agencies. And certainly the workers' pay is going to be reduced because their share of income tax will be withheld along with other employment taxes. For this reason, workers often request to be treated as an independent contractor, as their net pay may be higher than if they would have been treated as an employee. Other benefits that arise from a business using a worker as an independent contractor relate to a whole host of laws that regulate the treatment of employees and are protective of the rights of employees. When businesses use workers and treat them as independent contractors, they're immune from most of these laws. For example, minimum wage, overtime laws, meal and rest period, record keeping in terms of pay stubs, anti-retaliation provisions, some civil rights violations. There's a whole host of laws that have been enacted to protect workers, but they apply to employees as opposed to independent contractors. So for this reason, businesses often prefer to classify workers as independent contractors. Another benefit that people don't always think of in treating workers as an independent contractor relates to employee benefit plans. When workers are treated as employees, they're going to be allowed to participate in most employee benefit plans that a company may provide generally to its employees. For example, the health insurance, 401k, sick pay, vacation pay, all of those type of benefit plans. When a worker is treated as an independent contractor, they are not going to have access to those benefit plans. For example, if a company sponsors a 401k plan, that company is not going to allow its independent contractors to participate in that plan. So it is a cost savings factor for the business to treat a worker as an independent contractor. So when you look at the list of benefits that businesses have by treating a worker as an independent contractor, it may give you an idea as to why there's a crackdown on worker classification. The idea is that workers are being deprived of workplace protections. Companies using independent contractors have an unfair advantage by avoiding tax liabilities, and in fact, the government loses millions of dollars in tax money each year as a result of worker misclassification. And this really explains in part why there is such a continuing crackdown on worker misclassification, with laws being modified to narrow the ability to properly classify a worker as an independent contractor. California's Dynamex case that Tom referred to earlier is just one example of this. So what are the risks in misclassification? We've talked about benefits, and at the beginning of a relationship, when a business and a worker decide to and agree on an independent contractor relationship, the risk always seems very minimal. And this is partly because at that time, both the company and worker are happy with the independent contractor status. However, in actuality, the risks are pretty substantial. Generally, you're going to identify misclassification when an audit is conducted by a state or federal employment tax agency or the DOL or some other state agency. And those agencies are going to look at whether employment taxes have been paid, whether there are wage and hour violations, a whole host of things that will involve the proper classification of workers. Potential liabilities, well, the potential liabilities that I think people generally think of is the employment taxes. If you've treated a worker as an independent contractor, you haven't paid in the employment taxes that would be due on the compensation you paid to them. But there are, and that liability can be substantial, but there are a host of other liabilities that I don't think people necessarily think of at the start of the relationship. We talked about employee benefit plans earlier. Well, there can be liability associated with the company's failure to allow that worker to participate in the employee benefit plans. The worker can bring a claim that he or she should have been entitled to participate in the company's 401k plan because that worker should have been treated as an employee. That in itself can be a substantial liability. Other substantial liabilities that can arise include overtime obligations, unemployment insurance, meal and rest period penalties, and a number of other wage-related claims that a worker can bring. So how could this happen? Again, you generally start out with a worker that's very happy with his or her status as an independent contractor. How is the misclassification issue going to arise? Well, first of all, it can happen if you stop using the worker's services. If the worker doesn't find new employment or other independent contractor work, and he or she files an unemployment claim, suddenly that worker who requested to be treated as an independent contractor in the beginning is now adamant that he or she should have been treated as an employee. And frankly, this is the way many state employment tax audits arise. An unemployment claim is filed by a former independent contractor The state agency makes a determination the worker should have been treated as an employee and sends the matter to the audit department to generate a tax audit. Other ways tax audits can arise can be due to a number of things. In my practice, I handle a lot of tax audits. I probably see 90% of those tax audits arising from unemployment claims. However, we also see tax audits arising when there are a large discrepancy in the number of 1099s filed by a business from year to year. For example, perhaps your business filed a small number of 1099s in 2016 and a very significant number of 1099s in 2017. That can absolutely trigger a tax audit. Other ways that employment tax audits can be triggered include a worker receiving a W-2 and a 1099 in the same tax year. Now, that's not to say that there's no circumstance where that would be proper. There are circumstances where that is what should be done, that the worker receives a W-2 and a 1099 in the same year. Having said that, it absolutely can trigger a tax audit, and so you're going to have to be ready to explain why you had one individual that legitimately received a W-2 and a 1099. Other ways tax audits can arise are when you have a disgruntled worker that files a wage and hour claim, and then that's referred to a taxing agency, or the worker files a Form 8919 with the IRS. And then there's always the anonymous complaint that can occur as well.
So in looking at what an independent contractor is, it often depends on who you're talking to. There is no uniform definition of an independent contractor. Different government agencies, different jurisdictions, state and federal, apply different tests. So as attorneys, as businesses, we see conflicting rules, different court decisions, and they are very detail intensive. So what you see in one situation may have a different result, and the facts will matter significantly. At the National Labor Relations Board, they have relied upon principles of agency law. They've looked to the restatement, and they look to what some might consider traditional common law principles. At the Internal Revenue Service, there is a multi-factor test, which is lengthy and oftentimes looks to many of the same details, but the format in which the inquiry is made can differ. Then, if you look at Title VII of the Civil Rights Act of 1964, the Age Discrimination in Employment Act, laws meant to prevent discrimination in the workplace, there is yet a different test, a hybrid of the right to control test and what is known as the economic realities test, which I'll talk about a little bit more. The Fair Labor Standards Act and the Family and Medical Leave Act look to the economic realities test. So what is this economic realities test? The United States Department of Labor used the economic realities test in recent years, and the way that test is used is by looking at a set of facts, which I would say in summary looks to the dependence of the worker upon the business for a livelihood. And the factors can be spelled out as follows: the degree to which the worker's work is controlled by the organization, the business providing the work. Number two would be the worker's investment in facilities and equipment, if any. A way to look at that is, does the worker provide the truck, the tools, the various things he or she would need to operate in business? If it's the business that's doing it instead of the worker, it's more likely an employee status. Number 3 is the worker's opportunities for profit or loss, if any. If you are truly an independent contractor, you are a separate and distinct business, and you might make a profit, you might have a loss. However, if you are simply showing up and receiving pay for what might otherwise be considered a wage, that's not really the sort of risk involved in business to be an independent contractor. Factor number 4 is the amount of any initiative, judgment, or foresight this person uses in open market competition. If you are truly a business person, an independent contractor, you are going to have a wide array of discretion, the ability to succeed or fail, and your business will succeed or fail accordingly. However, if you are subject to rules, control, the expectations in a very detailed drill down way by the business that uses you, you are more likely an employee. Let's look to the permanency of the relationship. I gave the example earlier of someone calling a plumber to come to a business and unclog the sink, and then that plumber leaves. If that is a short-term thing, do this project and leave, there's no real permanency to that. However, if you are showing up at the same place at the same time for 6 months, a year, or longer, that is something that is more permanent and more likely to indicate employee status rather than independent contractor status. And finally, factor 6, whether and to what extent the worker's work is an integral part of the organization's business or activities. If you are a truck driver and you are allegedly an independent contractor of a company that drives trucks or a company that's in the warehousing business, you are very likely an employee. If you are doing something distinguishable from the mission of that business, you are more likely an independent contractor. So with regard to that Department of Labor guidance, there was an interpretation issued in July of 2015 confirming use of the economic realities test, and it de-emphasized the sort of control which had traditionally been a part of independent contractor analysis, the so-called right of control test, and focused instead on economic dependence. Does the individual in question really rely upon a particular business to make a living? And the analysis looked to the relative investment by the worker as opposed to the employer's investment. So if the business is providing the money, the resources, what the individual needs to do the work, more likely employee status. If you can show that the individual in question is purchasing or in the process of purchasing equipment, and there is some control, discretion by that individual in terms and responsibility to pay, then it's more likely independent contractor. So integral part of the business is a key. So the example on the slide is given a construction company that does framing work and carpenters. If they are integral to the business, such as they would be in a framing environment, actually building the structure of a building, they are integral to the business, more likely to be employees. And as I mentioned, permanency of the relationship, the indefiniteness or permanency suggests employee status. So how do we know if a worker is properly classified? In California, the Division of Labor Standards Enforcement, or the Labor Commissioner, more informally, has looked to a test in the past from the S.G. Borello case, a decision from 1989. And in that case, looking at many factors, the court said an individual will be considered an employee where the employer exercises all necessary control by direct or indirect means over the work details of the individual. So direct might be telling you to do something or not to do something. Indirect means more likely the potential to determine and to instruct how something will or will not be done. So Dynamex, which came along, which we mentioned a little earlier, impacts Borello and adds to the difficulty of an employer, a business more generally, to call someone an independent contractor. In the Dynamex case, as I mentioned, there is the ABC test, and someone who is alleging independent contractor status needs to meet all three of those factors. It was a radical change in California and really put an increased burden on businesses beyond what was already a tough challenge to beat a claim of misclassification. In rendering this ruling, the Supreme Court of California adopted a statute from the state of Massachusetts, where the ABC test originated. So, in summary, it's a much more difficult burden for a business to overcome a presumption, and it is a legal presumption that someone performing work is an employee. So, let's say you give someone a 1099 form. Let's say you have something in writing saying that they are an independent contractor, and the individual in question has signed it. Isn't that enough simply to say in a contract that someone is an independent contractor? No, it is not enough, because the analysis under all of these different tests in all these different scenarios looks to what goes on a day-to-day basis, and it looks to the arrangement, how it works, how the interaction is between the parties. So you may call it whatever you want to, but the contractual language alone will not determine on its own the independent contractor or employee status. And there is no single definitive factor to determine independent contractor or employee status. There are lots of different details at play. And with that, we can look at a couple of different rulings involving Uber. And Uber has been at the forefront of fighting this misclassification battle. And in one case involving the California Labor Commissioner, the Labor Commissioner held that drivers for Uber are employees. And Uber argued that they are an app, they are a technology platform, and that they do not employ the drivers. But the Labor Commissioner said, no, the services provided by the drivers are an integral part of the business. They obtain passengers, and drivers provide the service. The California Labor Commissioner applied the factors from the Borello case. Uber vetted the drivers, put restrictions on vehicles used, gave the drivers the smartphone app, monitored approval ratings, and the drivers had no ability to negotiate their own fees. So if you are an independent contractor, you're going to negotiate your own fees because you are ostensibly an independent business. So that was under Borello, that was pre-Dynamex. In the O'Connor case involving Uber again, this was federal court, not the Labor Commissioner, and the federal court allowed the drivers to move forward with a class action over wage and hour issues, alleging back wages, sick leave, expense reimbursement, and unpaid benefits. So the exposure is big, and the landscape is very unfavorable for a business that is looking to consider someone an independent contractor. With that, I will turn it back over to Cindy.
So Tom talked about a couple of the tests that are used in various circumstances. He talked about the DOL Economic Realities Test and the Dynamex ABC test. I would like to take a little bit of time to review the IRS criteria and what the IRS will look at in making a worker classification determination. I think most people have probably heard of the IRS 20-factor test. This is the test that the IRS previously used, and it was a set of 20 factors or criteria that were used to determine whether a worker was properly treated as an independent contractor or instead should have been treated as an employee. Well, the IRS has changed its test, but the substance of that test hasn't really changed. It's more the structure of the test that has changed. Now the IRS looks at 3 broad categories and a number of factors under each category. The 3 broad categories that the IRS will look at are behavioral control, financial control, and the relationship between the business and the worker. We'll go through these three categories in more detail, but keep in mind as we're going through these categories that no single factor is determinative. It's really a sliding scale, and the more factors that you have that lean towards a finding of employment, the more likely the IRS will be to conclude that an employment relationship exists. And if I could take a second to say, in general, well, the various agencies use different tests. In general, if you can structure a working relationship so that you're in good shape under the IRS test, you're probably going to be in pretty good shape under most of the other tests that are used by other agencies. I do have to accept out of that the Dynamex ABC test, because this is really a very strict standard that oftentimes, even if a business can pass the IRS tests and the tests of other agencies, they may not be able to withstand that ABC test. So let's first look at the first category that the IRS reviews when they're looking at the worker classification issue. They first look at the behavioral control factors. And what this means is the IRS is going to look at whether the company has behavioral control over the worker. Does the business or employer have the right to direct and control the worker? I want to point out one thing before we look at these factors here. The focus here is on the words right to control. The business doesn't have to necessarily actually direct or instruct the worker on how to do things, as long as it retains the right to do so. So how does the IRS determine whether you've retained the right to control a worker? Well, they will look at various things, like whether the business owner is giving the worker extensive instructions on how to do his work. If so, that's a very strong indication that the employer has behavioral control and the worker is an employee. For example, does the employer tell the worker where he should do the work, when he should report to work, when he's allowed to leave work, what the business attire is, what kind of dress should he wear to work? Does the worker have to wear clothing with the company's logo on it? Does the company tell the worker what tools or equipment to use, who he or she can hire, whether he or she has to personally perform the services, where the worker should purchase any supplies he or she may need? In general, the more detailed instructions that the company is giving the worker, the more it indicates that the worker is an employee. And the less detailed instructions obviously reflects less control, and it makes it more likely that you may meet your burden of proving that the worker is an independent contractor. Another thing the IRS is going to look at under behavioral control is training. Is the business training the worker on how to do the job? Independent contractors shouldn't have to be trained by a business, because the idea is that they already have the skills required to operate their own business in the field that they're providing services. You see the training issue arise in a few contexts. One area where I see it is when I'm reviewing independent contractor agreements. It's very important that there's no reference to training. Also, auditors will almost always ask if there are required meetings or training sessions or anything similar, and you need to stay away from requiring independent contractors to attend meetings, attend anything that could be construed as a training session by the employer. The next broad category that the IRS is going to look at is the financial control factors. And here we're looking at whether the business aspects of the worker's job are controlled by the company or the business. A true independent contractor should have the right to set his own prices for his services, should have unreimbursed expenses that the company isn't going to pick up for them. So the IRS here is going to look at who provides the supplies or equipment. If you're treating someone as an independent contractor, you want to be able to show that any supplies or equipment that that worker needs, they bear the cost. They have to provide. Office space. Who provides the office space? It's preferable if there is no office space provided to an independent contractor by the company. Now, that's not always the case, but you want to minimize that to the extent possible, and you want to be able to show that that independent contractor has his own designated office space outside of the company's premises, even if it's a home office. The IRS will also look at expenses again, and whether the worker markets his or her services to the public. And this is a very important criteria. You want to always be able to show that that worker advertises his or her services, perhaps get a copy of the worker's business card. If the worker that's providing services has a web page, that's ideal. Anything that shows that worker has an investment in his or her own business and markets his or her services to the public. The third criteria that the IRS is going to look at is the relationship factors, the relationship between the business and the worker. Is there a written independent contractor agreement? Now, this is an interesting factor. You always want to have a written independent contractor agreement. Having said that, it's never going to be the thing that carries the day and saves you if your relationship, a company's relationship with its worker, is being questioned. However, it certainly can hurt you if you have terms in it that talk about required meetings, talk about training, reimbursed expenses, control of the company, supervision, those type of things. A written contract with those terms can certainly hurt you. So it's very important to carefully draft your independent contractor agreement. Under the relationship factor, the IRS will also look at, is the independent contractor on the company's health insurance plan? Well, we talked about this before, the employee benefit plans. The idea is that this independent contractor, this worker, is not an employee, so they should not be receiving employee benefits or benefits that the company is providing to its employed workforce. For example, the independent contractor shouldn't be on the 401k plan, shouldn't be getting sick pay, vacation pay, those type of employee benefits. The IRS will also look at the relationship. How long is it continued? Whenever there's a long-term working relationship, that's more likely to be considered an employee-employer relationship. And then the IRS finally will look at whether the services being provided are an integral part of the business. Under the IRS factors, the integral part of the business isn't determinative. It's just one of the factors on that sliding scale. However, I will tell you that state and federal taxing agencies do really look at this factor, and it can be hard to overcome when the services provided are an integral part of the business. Now, we've gone through the IRS general rules and the factors they're going to look at when they're making a worker classification determination. But I want to point out that there are some exceptions, and there are some circumstances where a worker will, by statute, be considered to be an employee. For example, corporate officers are always considered to be an employee by the IRS simply because of their status as a corporate officer. So if you have a president of a company that's providing services and receiving compensation, but it's characterized as, he or she is characterized as an independent contractor, the state or federal taxing agency, in almost all cases, will recharacterize those payments as wages. One thing that is important to keep in mind if you're going through a tax audit, particularly an IRS audit, is even if you don't meet the criteria that we just discussed for treating a worker as an independent contractor, you may still be able to save your classification by looking at the IRS's Section 530 relief. And this is a safe harbor where the IRS may determine that a worker should have been treated as an employee, but it determines that under Section 530, you were entitled to instead treat that worker as an independent contractor, even though under the 20 factors, the worker should have been treated as an employee. And here, the tests you have to meet are 4 tests. You have to have a reasonable basis for treating the individual as an independent contractor. And that test doesn't sound that hard, but it really is harder than it sounds. To have a reasonable basis, you have to show that there's judicial precedent, there are IRS rulings or IRS advice, or perhaps you've had a past IRS employment tax audit where you weren't assessed for those workers. So it's not that easy of a standard to meet, the reasonable basis standard. Secondly, you also have to be able to show that you've consistently treated all the workers in similar positions as independent contractors. And again, this sounds like it may not be that hard to meet, but it's not uncommon at all that businesses have mixed workforces, and they may have positions where some workers are treated as employees and some are treated as an independent contractor. If you're applying for Section 530 relief, you can't have that situation. Third, the business has to have filed all its required returns, including its federal employment tax returns and issuing its Form 1099s on a timely manner and consistent with its treatment of the workers as an independent contractor. And finally, the business needs to be relying on a long-standing industry practice of treating similar workers as independent contractors. Another thing to keep in mind, aside from Section 530 relief, if you are not currently under a tax audit, the IRS does offer a voluntary classification settlement program that employers can go into to admit that we have X number of workers. We thought they should have been treated as independent contractors. When we look at them now, we see that they probably were more properly treated as employees, and we'd like to reclassify them. And the IRS, if you voluntarily go into this program, it allows you to reclassify these workers at a significant reduction in the potential liability if you would have been audited by the IRS. To be eligible for this type of program, you have to have consistently treated your workers the same as independent contractors. Again, you have to have filed all Form 1099s for the past 3 years for those workers. You can't be under an employment tax audit or any other audit on the classification of those workers. And if you've previously been subject to an audit that related to the classification of those workers, you have to have complied with the prior audit results. So let's talk about a couple of cases that I think are interesting. And the reason I think these cases are interesting is because their sole determining factor in these cases seems to be the length of service and the economic dependence of the workers. In Cromwell, you had a group of plaintiffs that were splicers that were working on telecommunication line repair after Hurricane Katrina. They didn't have any training by the company. They were already trained to perform the services. They had their own trucks, their own testing equipment. All other equipment was theirs for the most part. The company did not control their work, but yet the court found them to be employees, and it was based primarily on their longevity of service with the company. They had worked for the company 11 months, and they had worked exclusively for the company, and the court said that these workers were economically dependent on the company and therefore were employees. You contrast that with Thibault, and it had very similar facts, but the worker had only worked for 3 months for the employer, and the court found that the worker was an independent contractor. So here you have differing results, and it really is based almost solely on the longevity of service. Another case I'd like to touch on is Devers, and this is a Kansas case involving a golf pro, and this was interesting, again, based on longevity of service. In this case, the golf pro had worked at the golf club for 27 years, which, as we've discussed, is a very bad fact when you're trying to prove that that worker is an independent contractor. Another bad fact, he started as an employee and was an employee for 11 years and then changed to independent contractor status. That again is a very bad fact in the worker classification determination. He was required to devote full-time duties to the club. He conducted all golf tournaments, supervised golf activities for members, maintained and operated the pro shop, and he paid all the fees and expenses for his certification. There was no supervision by the club of his services. And then I think one of the saving graces is that he made all decisions with respect to merchandise in the pro shop, and he purchased the merchandise under the name Andy Devers Pro Shop, and then he received all proceeds from the sale. The takeaway here, even though we had some very bad facts in terms of longevity of service and starting as an employee and switching to an independent contractor, is that in this case, the company could show that this golf pro held himself out to the public as an independent contractor and as having his own business with the business name Andy Devers Pro Shop. And that really saved the day for him.
Thank you, Cindy. And I am going to discuss some distinctions between independent contractor and employee status to illustrate how the analysis is made, and hopefully that will provide a little greater depth of understanding of these issues. In terms of selection of services, an employee will typically provide the services requested by an employer. An independent contractor, on the other hand, should be able to decline the assignments. An employee is going to have to do it. An independent contractor is an independent business person who can say no. In terms of training and meetings, employees are often trained by the employer. They may have orientation. They may have certain steps they are required to go through to become familiar with the business. On the other hand, an independent contractor is not going to have those required instructions, background training, or required meeting. An independent contractor is there to show up to do a special assignment and then to leave in the typical situation. In terms of hours of service, employees work a schedule. In most circumstances, they have a shift, they have set hours. The employer decides what those hours are, when the employees are needed, when they will work. An independent contractor is typically hired on a project basis. It could be a particular job, it could be a set specific period of time, and the independent contractor may have his or her own employees who the independent contractor will decide when and how to schedule. So the independent contractor has much more leeway in terms of determining how and when the work is done. In terms of full-time and outside work, there are distinctions. An employee will typically devote his or her full-time service to an employer. On the other hand, an independent contractor has the freedom to decide whether to provide services elsewhere. It could be many different places where the independent contractor performs services, multiple jobs, and the suggestion that someone is in business for him or herself is at the heart of being an independent contractor. There should be inquiry into the availability of evidence of an independent business. An employee is not going to advertise services to other people, but an independent contractor typically would do that because they are running a business. They would typically have a business card, business license, a business name, and they may operate through a corporation, an LLC. So that sort of formality to show that they are truly in business for themselves will be helpful to make that distinction. With regard to benefits, employees typically receive benefits such as vacation, sick leave, other things that an employer may offer. An independent contractor is not going to receive benefits from a business. They are, again, in business for themselves. They might provide themselves benefits under programs that they establish themselves, but they should not get it from the entity where they are performing services. In terms of payment, an employee is going to receive a paycheck based upon the service that they provide, the hours they provide to an employer. It's typically treated as wages with deductions and so forth. An independent contractor is typically going to be performing jobs in multiple places and is going to be invoicing and receiving payment like a business receives payment, not with wages and payroll deductions, but based upon invoices and charges that are invoiced like a business would generate. In terms of location of work, an employer is going to tell an employee where to do the work that is needed. An independent contractor is going to have greater discretion, greater autonomy to determine where to work to perform the services that are rendered. It may be at a facility of the independent contractor's choosing, perhaps the business location of the independent contractor. There are distinctions in terms of profit, loss, and rates. An employee does not make a profit or loss. They are paid to show up and work. An independent contractor sets his or her own rates, often negotiates with a client on how much will be charged, and then the independent contractor, as a business person, is going to make a profit or a loss based upon decisions, negotiations, services rendered, and so forth. In terms of tools and expenses, an employee will have the tools and equipment furnished by the employer. Expenses will be paid and reimbursed. as required by law. An independent contractor is going to provide his or her own tools and equipment, and is not going to be necessarily reimbursed for everything that goes on. There is the terms are going to be set by contract. In terms of attire, employees may be required to follow dress or uniform standards because they are working at the direction of the employer. An independent contractor will typically determine for his or herself what to wear and may have a completely distinct business identity, a different uniform, different logo on the clothing that the independent contractor wears. So with all of those distinctions, all of these tests, I'm going to sum up what we've talked about in a few tips. And they are as follows. If you are operating a business, if you use people you consider to be independent contractors, if you are an attorney advising a business that is looking at independent contractor issues, or if you are an attorney advising individuals who you believe may be misclassified, some things that you need to be looking at are a comprehensive review of the current employee classification system and independent contractor relationships. Dig into the documents, the facts on the day-to-day working relationship, and get the details so that you understand what's really going on. You want to review the industry and position classification standards and best practice guidelines. So what goes on in the trucking industry may be different from what goes on in the club industry. That may be different from what goes on in other industries altogether. We've talked about several during the course of this program, but understand that one size does not necessarily fit all, and it's good to know what the practices are in the industry you're dealing with. You should be looking at internal reviews if you are working with a business in preparation for audits and employee litigation. That way you know what's going on. If you have written independent contractor agreements, you should be checking the language that is used to assess what is required. What sort of control is there? What sort of autonomy is there? Be thinking about the ABC test if you are dealing with California and Dynamex. And frankly, what goes on in California and Massachusetts under the ABC test may well be the most restrictive and may be something worthy of consideration in other places. So review that language and be careful with the agreement language that you use. You may want to consider maintaining records of hours worked, even for people you deem independent contractors, to aid in potentially defending against large lawsuits. That's not to say that you're requiring that certain hours be worked, but simply that you're keeping a tally. And in the event that there is litigation or an administrative claim, you can refer back to that to say, with some degree of reliability, that there were only so many hours worked on a given day. And of course, as issues, as claims, as questions arise, you should consult legal counsel to make sure that you are getting appropriate input for the issues and objectives that you are dealing with. That concludes our program, and we thank you for listening today, and we are always interested in answering any questions that the viewers, the listeners may have. Thank you.